friends, welcome to my YouTube channel. Today in this video, my humble effort is to get you all acquainted with the legal term res judicata. Res judicata is basically based on three age-old legal maxims which are nemo debet bis vexari pro una et idem causa, which means that no person shall be twice vexed for the same offense, or rather for the same action. Second maxim is interest republica ut sit finis litium, which goes on to say that it is in the interest of government that litigation should come to an end. And the third legal maxim is res judicata pro veritate acceptor, which means that decision of a judicial authority must be duly accepted as correct. Okay. On behalf of this maxim, there is another citation which is 1987 KHC 58 between Sumati versus Dakshayani, wherein the Honorable Court stated that court is entitled to decide rightly and wrongly. Erroneous decision, if it is by a competent court, attracts res judicata, and the remedy is only by way of appeal or revision. Moving forward, res judicata is a principle which is based on public policy, as it prevents the law from being abused. For example, let's say you locked horns with your neighbor. If he is rich and affluent, he'll be successful in harassing you continuously with repeated litigations over the same cause of action. This is why it is also called rule of conclusiveness of judgment. Okay. In CPC, we find provisions with regard to res judicata in section 11. Section 11 defines res judicata as follows: no court shall try any suit or issue in which the matter directly and substantially in issue has been directly and substantially in issue in a former suit between the same parties, or between parties under whom they or any of them claim, litigating under the same title, in a court competent to try such subsequent suit, or the suit in which such issue has been subsequently raised and has been heard and finally decided by such court. Now, a bare reading of this definition, we can see that the structure formation might not be in a way which makes a layman understand what it is all about. So basically, a gist of what is stated is that if a suit is filed over a cause of action between the same parties under the same title, then if the suit is adjudicated, a subsequent suit is not maintainable. Now, in order to better understand this definition, section 11 itself goes on to give 8 explanations. Okay, first explanation, I'm not going to recite the entire explanation as such in this video, because that would definitely be a waste of time. What the explanation states, a gist of it is as follows. The first explanation is former suit. That the first explanation, what it says is that a former suit is a suit which is adjudicated at earliest point of time. It is not the institution of the suit which counts, but adjudication of the same. For example, if a suit is instituted in the year 2012 and a subsequent suit is instituted in the year 2013, if adjudication of the suit which is instituted in the year 2013 is before the adjudication of the suit which is filed in 2012, then it is the suit which is instituted in 2013 which would be considered as a formal suit. Okay, so that is the gist of explanation 1. Now explanation 2 is that provision for appeal from judgment of a court is not a factor in deciding the principle of res judicata. Okay, irrespective of whether there is provision of appeal from a decision of a court, res judicata will be applicable. Now third is subject matter. Okay, a matter has to be alleged by one party and either admitted or rejected by the other. Okay, now the fourth is actually a little serious in matter. Oftentimes we see young lawyers in a hurry, they file the suit, okay, without thinking several aspects of a suit. For example, see, what it states is that might and ought to have been raised. Okay, so if there is a ground of defense or attack which might and ought to have been raised in a suit, if it is not raised in a former suit, then it is deemed to be raised in the subsequent suit. Okay, it is under this explanation that we find the principle of constructive res judicata. Okay, if a ground of attack or defense which ought to have been raised is not raised in a subsequent suit, that cannot be raised. That is the gist of constructive res judicata. Here I'll explain you a case which was heard by the Honorable Court. The citation is 2005 KHC 2239. Okay, it is Ramadhar Srivas versus Bhagwan Das. Okay, wherein the Honorable Court stated that the whole point of this explanation is to compel plaintiff or defendant to take all the grounds of attack or defense in one and the same suit. This is in line with the second maxim which we had spoken about, that is, it is the interest of the government that adjudication should come to an end. Okay, now similarly another citation which is very relevant with regard to constructive res judicata is 2015 5 KHC 174. Okay, in this case what happens is the plaintiff initially argued about their right of permanent lease, which was rejected by the Honorable Court. And what happened is in a subsequent suit an issue was raised wherein they argued about their right to have a second renewal of lease. In that case, the Honorable Court stated that this definitely would come under the purview of constructive res judicata. Okay, now the fifth point is relief. If a relief is claimed in a suit and if it is not expressly given, then it is deemed to be refused. Okay, what is not expressly granted is refused. Now the sixth point deals with representative suit. Okay, here what has to be considered is that the suit should have been filed in a bona fide manner by complying with all the conditions. Okay, in that case the judgment would be considered as a judgment in rem, and all people who are interested in the same is bound by the decision of court, and res judicata will be attracted in the same. Okay, Now the next point is court of limited jurisdiction, or rather court of exclusive jurisdiction. Now what it goes on to say is that court of limited jurisdiction competent to decide the issue and decision rendered, it will act as res judicata even if it is not competent to try a subsequent suit. Okay, so basically let's say a suit is filed and a decision is rendered by a court of limited jurisdiction, and a subsequent suit is filed over which the court which gave the decision in the former suit is not competent. Even in that case, res judicata is applicable. It is in AIR 1978 Calcutta 440. The Honorable High Court of Calcutta had held that court of limited jurisdiction are court other than ordinary civil court. Such as revenue court, land acquisition court, etc. Okay. Now moving forward, there are actually 5 conditions which attract the provisions of res judicata. It is again stated in a judgment which I had earlier stated, which is 2015 5 KHC 174. It is the party's name is Indra Motor Service versus Panakat Nasruddin. Okay, where the 5 conditions are: the matter directly and substantially in issue in subsequent suit, or issue must be the same matter which are directly and substantially in issue either actually or constructively. Constructive res judicata I had explained. The second condition is the former suit must have been a suit between the same parties or between parties under whom they or any one of them claim. Okay, so it is under this things such as fiduciary relationship, agent principle, etc. comes into play. Third condition: the parties as aforesaid must have litigated under the same title in the former suit. Fourth, the court which decided the former suit must be a court competent to try the subsequent suit in which such issue is subsequently raised. And the fifth, the matter directly and substantially in issue in the subsequent suit must have been heard and finally decided by the court in the first suit. Okay. Now the next point is, okay, res judicata is a mixed question of fact and law. Okay. It might so happen that in a former suit and the subsequent suit, the parties are same, but the cause of action or the property in which the dispute has arisen might be different. In such case, the principle of res judicata will not be attracted. It is because of this reason in 2016 KHC 6347, the Honorable Court had stated that res judicata is not a pure question of law. Facts has to be thoroughly checked to see if a suit is hit by res judicata or not. Okay. When we are at this point, I would also like to get you all acquainted with the term cause of action. I am sure many might be well aware of what it is, but for those who are not aware of it, cause of action means every fact which, if traversed, would be necessary for plaintiff to prove, to get a judgment in his favor. Okay, this was actually stated by the Honorable Court in 2005 KHC 1649, which was a suit between Swami Atmananda and others versus Sri Ramakrishna Tabovanam. Okay. Now, in my next video, I would be talking about a situation wherein res judicata will not be attracted, and also the application of res judicata in different proceedings. Thank you for watching my video. I'm hoping that you all would enjoy and would benefit from this video. Stay tuned. Watch my next video. Thank you so much.